All right. Welcome all to the third episode of Legal Armor Podcast, where we discuss legal topics relating to real estate, construction, and rent. I'm your host, Roald Trump, an attorney for over 8 years, and I'm here to answer some common questions received in these three areas. Before we proceed, if you're watching us on LinkedIn, remember to follow us and connect with us. And if you're on YouTube, do not hesitate to subscribe. With that being said, we can start today's show. Also, guys, don't forget to share it with people who might have value in might find value in the content we discuss. Let's start with the first question. Do I have to pay the contractor for extra work? This is a good question. This is a common question. This is a common discussion point in legal battles, especially in contracting cases. Very common, oftentimes because as we mentioned in the previous episode, in construction law, what you see is that a lot of things are done verbally. There are a lot of people, a lot of movements, a lot of factors that play a role. So the chances of problems resulting from all this volatile situation is extremely big. Now, with regards to extra work, what is extra work? Let's start there. And in what instances do they arise? Extra work basically means work additional to what the parties had agreed to in the original contract. So, let's say, just to give a simple example, if you ask the contractor to give you in an estimate for the for creating a for building a house with 3 bedrooms, 2 bathrooms, and while the contractor is working, you ask or you request a fourth bedroom, then that fourth bedroom is additional work, extra work, or more work. Those are all synonyms, of course, guys. So that's one instance when more work happens. Another instance where it happens is that, let's say, when the house is physically visible and the owner can see, let's say, how the structure is, the owner might decide that maybe she doesn't want a wall there after all, or maybe she wants a ladder there, and so on and so forth, right? So those are examples of those are basically the two instances where extra work happens the most. A third instance in which it happens the most is when the contractor, or at least something went wrong with the building of the house. For example, while building, they realized that the ground wasn't as optimal as they wanted it to be, or the garden isn't as big as they thought. So then they say, you know what? Or at least the garden won't remain as big if they really build out finish the house. So maybe on the painting, on the drawings, it appeared that the house would remain with a lot of, or at least the property would remain with a lot of ground to create a garden, etc. But while building, the owner sees that it's not as much as it wanted it to be, or the contractor does something wrong while building, and then instead of saying, okay, let's, for example, break down this wall and build it from scratch, they will say, parties can agree that, okay, we build it wrong, well, let's use what we have now and continue building something different, right? Those are instances in which it happens. Now, should you pay the contractor for this extra work? one of the most common the one of the most common answers you will hear from a lawyer is, it all depends on the situation, right? So instances in which you would have to pay for the additional work. uh, Examples can be the if there's a written approval. So if the contractor presents you with the extra work and you agree, and he not only presents you with the extra work but also with the costs, and you agree with the extra work and the costs, even it doesn't matter if the reason for building was due for the extra work is due to the contractor's fault. If you sign and agree that you would pay and cover the extra work as the owner, then you would have to pay the extra work because that's what the parties agreed upon. Another instance, unforeseen circumstances that are not due to the contractor's fault. Maybe the architect made the wrong calculation. The contractor was building it, and as it was building it, it realized that, no, this isn't going to be turn out the way I expected it to turn out. That can be an instance in which you would have to pay for the additional work, right? If there's a scope change, so you agree to one thing, that's the example I used a while back, like a couple of minutes ago. You agree on a 3-bedroom, two bathroom house, and while the project is ongoing, you say, you know what, I want a 4th bedroom. That's a change of scope, and then you would need to cover it as well. If there's a price increase of materials, then you would also need to pay the construction, the constructor, the construction company for this for these materials, if these are materials that the contractor had to deliver. Because sometimes in projects you have, so parties agree that certain materials and certain products will be delivered by the contractor, and perhaps a kitchen, maybe the owner says, you know what, I don't want my kitchen from Koiman, I want my kitchen from Saudi Arabia, for example, or the Emirates. And then the owner would be responsible for that, for those expenses. So if those prices increase, yeah, it was the owner who would have to pay it anyway. So in that case, of course, a contractor cannot charge the owner. But in the first example that I gave, where the contractor had to deliver products and materials, and the prices of these products and materials had increased, then yes, it would have to, the owner would need to cover it. One asterisk I want to mention in this case, because this is important to know and remember, it all depends. So everything depends on what's written down in a contract, but also how the contractor formulated the offer. If the contractor was smart, the contractor would have made a specification or a distinction between prices of materials, prices of products, and hours of labor, right? So then you can exactly see, like, okay, this is, and for regards to the prices for the products, they need to be specified for this to work. Then you would need to see, for example, concrete, an X amount, the painting, this amount, tubes, this amount, wiring, this amount. So it would need to be specified, because then the contractor can say, this was the price at the moment of estimation when we went to the building, we went to the hardware store, This is the amount we saw, and this is what we want you to pay. And or at least this is what you had to pay, and now the prices have changed, you need to pay a bit more. But then the contractor can clearly show, hey, you're not actually paying me, you're actually compensating me for the prices, the increased prices. If, however, the estimate just says materials and then an amount, let's say 200,000, and it's not specified, it's going to be very difficult for the contractor to request more payment. In that case, it wouldn't necessarily be more work, but there is an increase in price, right? But the contractor will need to prove that there is an increase, and that the increase, that the amount he offered was based on a certain calculation. If it's not, then it will be very difficult, almost impossible. Yes, but there are also certain situations where this is not possible. Parties can agree, for example, in a contract that in certain instances, the contractor will not get paid for additional work. That can also be in a contract. If the more work is due to a mistake, a mistake by the contractor, then the contractor is by law obligated to repair that. So it would be very unwise as a owner to pay for the additional work, the extra work, if the extra work is due to a mistake by the contractor. Yes, and so on and so forth. So these are just like a couple of instances where this is the case. Remember that this is all, the content of the show is to be regarded and to be treated as a general advice. It's not a tailor-made advice. So if you need advice specifically geared to you, we strongly urge you to either book a Rent Our Legal Brain session with us, or go talk to your lawyer if you already have one, just to see whether or not what you want to do is possible and desirable in your particular situation. Let's go to the next question, which is, I see a rent question. Can I turn off the water flow if my tenant does not pay me? This is a good question. It happens, not often, but it does happen. The owner will say, the tenant isn't complying, so I told him to get out, doesn't want to get out, so I'm gonna put some pressure, I'm going to turn off his water flow. Can you do that? Well, you can't do that. You first would need to break the contract, right? So you first would need to, if the tenant isn't complying, you would need to go to court, then then request an eviction, and after the eviction you can turn it off. And while the person is in there, of course you can so after you evict them, you will also sue him for the water, for example, that he used but didn't pay for, and so on and so forth. Water is the right to water is a fundamental human right. And as long as someone is living somewhere, that person has the right to access of water. If you turn it off, you run a big risk of being found liable for the infringement of a fundamental human right law, and you don't want that. So in instances like that, it does, I have to say, in the same breath, it happens. I don't know how frequent. I can say, for example, in 10% of the times, but it does happen. Some people do say, or you think, okay, I'm gonna just turn it off. I know people who, for example, just go in, the person's house and take out everything. That's not the way it works. You need to go to court and you need to request the judge to evict the tenant. And if the claim is simple enough, you can also see if you can request a claim to request a judgment based on which you can execute it, go to a bailiff, maybe seize parts of the salary, etc., to get paid what is owed. But that claim will not easily be accepted in summary proceedings, yeah, in Dutch kortgeding, if the if the claim isn't simple. So if it's not simple, you would need to start another procedure after the summary proceedings. You would need to start a normal procedure to request specifically payment of what you think is due. So yeah, the next time you're in a situation like that, instead of turning off the water, just approach your attorney and just go to court as fast as possible. What we also see is that in some cases, when there's a debt, the landlord will give so much flexibility. So much flexibility, and then months go by, and at some point there's like and I'm not joking, like a debt of 1 year, even 2 years I've seen. And there comes a point where after all those times the landlord says, okay, now get out and I'm going to put pressure, etc. No, don't do that. Don't wait 2 months. If you see that it's structural defaults, or you see that the tenant is continuously, or that this has like a 3 or more months of default, go check with your attorney so you can take actions and thereby so on time and limit your damages. Going to the third question. Why does the law protect the consumer from the professional? In our laws, we see that, and you also see it in court, the judge protects the consumer from the professional. A professional can be seen as someone that, whether it's in the real estate sector, the rent sector, the construction sector, or any sector, a professional is a person that is continuously involved in transactions in that sector due to his profession or his job. I'm going to say it again. A professional is someone that structurally is involved in transaction in in the scope of our show, continuously involved in real estate transactions, rental transactions, and construction agreements due to that person's profession. For example, he's an architect, or his job. For example, he is a constructor, or so he has a construction company, for example, right? So in instances like that, if that person, that person comes to meets a client, if that client is also a professional, let's say that client is a serial investor, has multiple investment companies, has or at least multiple investments in real estate, multiple houses or apartments that he rents out, multiple construction projects. So he's also continuously involved in transactions in those sectors. Then those two will be seen as two professionals. That person is not a consumer. A consumer is someone that occasionally, sporadically, will get involved in something like that. For example, a family that wants to buy a house or wants to build a house. It's not like they're building houses continuously to invest. No, they just want to build a house for themselves. So it's a one time transaction. Maybe they bought a house 15 years ago and they want to buy it again. Those people are consumers. So the law puts more pressure on the professional and more demands on the professional than on the consumer. What do I mean by that? Let's say the contract, of course, contracts are very technical, right? So the contract is, let's say there's a construction contract. And in the construction contract, all the phases are mentioned and all the materials are mentioned and all the hours that will need to be need to be put in the project are mentioned, and so on. So it's specified. And one of the things that's also mentioned is that they will install air conditioning. So they will install the ACs in the whole house, for the whole house. And it also specify how powerful the air conditionings are, right? So the power of the ACs. The consumer agrees because the price is good, the condition seems to be good. But after building, after the house is done and the air conditionings are installed, the client realizes that they're not powerful enough to keep the whole room cool. In an instance like that, the law will probably most likely protect the consumer. So if the consumer goes to the professional and say, hey, professional, you told me that the amount, so you gave me in your estimate the amount that I would need to pay in air conditioning, but it's just not powerful enough. The contractor cannot say, oh, you know what? Then what I will do is I will buy another air conditioning, but then you need to pay me for it. So I can install one or two more ACs for you, but you need to pay me. Or no, but this is just what you paid for. You paid for this. If you want more, you need to pay me so I can buy a more expensive one. The contractor cannot do so, at least not as easily. Right? What the law and a judge in this case will probably do is determine that because of the fact that the contractor is a professional and the client slash the consumer is not a professional and does not have that much experience, the client will put the burden on the contractor, because as a professional who continuously operates in that field, you know, or at least you should know, whether or not the products you choose and the air conditionings you chose in this particular case, that they were enough to function. You can say no, the contractor can say no, but that's what he paid for, because the judge will say no, that's what he paid for, because that's what you offered. This person is not a professional that knows that can understands it. The law doesn't demand that he goes and study all the different items on the offer, on the estimate, to go and see the units and see how much it is and if it's enough, etc. No, the judge doesn't go that far. The law doesn't go that far. The consumer, when saying yes, he said yes because he assumed that what you offered, in this case the air conditioning that you offered, were enough for the room because he didn't pay for the air conditioning. He paid to have a cool house. Cool as in cold, no pun intended. And now his house isn't cool. It's warm, and that's not cool. That's why what we need to do, or at least what a judge will do in that instance, is probably say, no, contractor, you're in the wrong. You need to pay up. Yes, there is an exception to the rule because there can be factors present that will make a court see the consumer not as a consumer but as a professional. And that's when and if the consumer hires a professional to advise him on the project. So if the client doesn't know anything and the client hires someone that is an architect, and the architect is tasked with checking the drawings and the specification and the estimate, and then he goes and hires a professional in the construction world who maybe has its own his or her own construction company, but then in this case he's hired or she's hired just to control and oversee the project. And if something goes wrong, then the judge will not regard the client as the consumer, because at the moment where in which he made the decision, he had the professionals in his corner to advise him, just like a professional or the professional had or probably would have had at some point in the business career. Right? Does this mean that it's best not to seek advice so you're seen as a consumer? I truly hope that you did not, or that at least that you did not take that away from what I said. Instead, what I'm saying is make sure that when you're approaching professionals to assist you, make sure first of all you do it, and make sure that you trust them as well. If you don't trust them, it's okay. There are a lot more lawyers, there are a lot more architects, there are a lot more contractors, and so on and so forth that can also advise you. So don't think in scarcity. There are an abundance of other alternatives. Never think that what's presented to you or what you know is everything you know, or the people you know, that's everyone you know that might be able to help you. There are always other people. You need to, however, be willing to invest at the beginning instead of paying afterwards. And we're gonna go to the fourth question. Should I put my house in my name? That's a good question. Should you or shouldn't you put a house in your name? Well, again, it all depends. It depends on a couple of factors. For example, well, before we talk about the factors, let's talk about the alternatives. If you go to the bank to request a loan for building a house, it's probably a personal loan, right? But maybe not maybe, there are other alternatives, other vehicles that you can use to put as the owner of the house. So you would have a BV and an NV and or an NV, or you also have like the foundation, the private foundation, and so on and so forth. Some people use companies legal entities from abroad, but that's not the purpose of this segment. our legal system provides enough benefits depending on what you want to do. So it has, if, like in all other countries, it's fairly limited in what you can choose, but very flexible as what you can do with what you choose. Um, a couple of things that play a role, and after I finish with this part, I'll tell you what you need to consider when choosing, right? Some things that play a role is how simple or complicated do you want it. A personal loan is fairly simple. Why is it simple? Because the bank knows, okay, Jane Doe is coming. Jane is married to John, so I'm gonna let John and Jane sign. John and Jane Doe are the owners. I'm gonna loan them their money, the money. They both have jobs and or income, and then if they don't pay, I have two people, and if they pass away and there's an estate, they leave the estate to their children. Yeah, estate in Dutch, nalatenschap. Yeah, okay, I can still claim, right? So it's fairly easy. It's also easier for financing. Banks will finance not only faster in our experience, but also against a lower rate. I have heard people who invest in real estate, who have invested in real estate, who requested personal loans, and if the bank said, "Oh, this is your second house or this is your third house," then you're doing it for business. So, although you don't have a company, we will charge a higher, we will apply a higher rent, right? But what you need to consider in instances like this is the liability question. Putting a house in your name means that you are liable personally. So if you do something that's not correct and you cause someone problems, legal problems, the person can sue you, and they can, technically speaking, depending on how big the claim is, of course, but they can seize your home and sell it to get their money. Personally, right? If you have a sole proprietorship, an eenmanszaak, and something goes wrong in that business of yours, you are personally liable for the wrongdoings, at least for the damages suffered by the other people, and you would need to compensate the victims for those damages, and they can also seize the house, even though the mistake was done in a business sphere, but because you had a sole proprietorship, they can take your house. Yes? If you have a house in your name and you get married, you don't have a prenup, and your husband or your wife, so your spouse, causes damages that he or she would need to compensate to the victim or victims, you might have not have had anything to do with that problem. For example, a car accident with terrible consequences, fatal consequences, but you would also need to, at least not you, your house can also be used as an object to sell in order to, for the victim to get the money, and uh, thus the compensation he or she deserves. So the personal liability is something that can play a role. On the other hand, if you have a business that's a BV or NV, maybe you, and let's say it's a very risky business or whatever, maybe you don't want, maybe in that case you wouldn't want to put it in that business, you're going to put it in your name, for example, because if something happens with the business, you are safe. Or you might say, you know what, I'm going to just create a different legal vehicle and do it, put it in that vehicle instead of my name. That's also, of course, a possibility. Yes. Another thing that plays a role is what your plans are as it relates to estate planning. Yeah. Do you have a will? In Dutch, a testament. Do you want to sell it and with the money go travel and not leave anything behind to your kids? Do you want to leave it to your kids? In what form do you want to leave it to your kids? Do you want to leave the ownership to your kids? Or do you want them to receive the benefits? But because you don't trust them, you would want to put it in the power and control of another person or company or entity, legal entity, I must say. Right? Maybe it's an apartment complex, 8 apartments, and you want them to profit from the revenue, but you don't trust them to control it because they run it to the ground. What do you want to do in the future? Are you building it to sell? Are you flipping the house, for example? Also things to consider. One important thing to consider, which isn't necessarily legal, well, it is legal, but it's a different area, is tax law. What implications do the tax laws relevant to the jurisdictions, either in Curacao, Bonaire, or Aruba, have? What are the implications for each choice, for each alternative? Sometimes, in some instances, for example, legally, so civil law, from my point of view, from my job, I want to protect the client from liability issues. But perhaps from a tax perspective, it's better to have it in your name because you wouldn't need to pay certain taxes. Or maybe it's the other way around. Same goes for estate planning, right? Certain options, and this is not a tax channel. So if you want tax advice, we highly recommend you to speak to a tax lawyer or a tax advisor. But taxes can also play a major role and oftentimes do play a major role in the decision you need to make. So you would need to determine for yourself what the purpose is of everything. And certain alternatives can imply that your children will receive the property, but against a high tax percentage, for example. And in other instance, maybe they won't receive the money, but they will receive the benefits without having to pay little to no taxes. Right? So that's a very, very, very crucial part to take into account. And also remember that the tax and the civil, so tax law and civil law have similarities, but they also have discrepancies. So there comes a point in time when you've acquired all the information from both expertise, you need to make a decision on your own and carry the consequences and the risks that come with it, because a decision without risks doesn't exist, right? And if you're gonna do it with a business purpose, then I I'm just gonna give like an anecdote. I have a client who is not based in Curacao nor Bonaire nor Aruba, but he is an investor in real estate, and he has a job because he always seeks personal finance, and he works only to receive the only so he can get a mortgage, because sometimes it doesn't matter how many assets you have or income from rent. If you have a salary, it seems as though it's easier for you to get a mortgage than when you don't have a salary. So he works 3 times a week. He's so happy working. He's so free because he's a millionaire already, but he just works to have that personal to get that personal loan, and then he flips houses, builds, repairs, upgrades, and then sells. Right? So all these factors play a major role in your decision. That's why it's important to sit down and think and determine for yourself, what is it exactly do you want? Do you want to build an empire? Are your houses or your investments, the real estate investments, are they going to be your retirement fund? So your pension. Maybe you don't trust the pension companies here and the insurance companies, and you say, you know what, I'm gonna do it myself. Maybe, I don't know, right? Are you gonna use the money from the income? Because sometimes, I mean, when you generate the money, if you're renting it, are you going to invest in the stock market, for example? Which, by the way, if you're gonna do it, please seek advice first. Don't just go risk hard-earned money in the stock market if you don't understand it. And that goes for every investment opportunity that might present itself, of course, right? So the to round it up, I before we close, if you believe that you want to do more with a house than simply put it in your name, if it's for yourself, then you can put it in your name. It's probably this most straightforward way. Unless you say, you know what, I want to not put it in my name because I want to separate it. It's also a possibility. But a lot of people don't have the investment mindset. A lot of people have the consumer mindset. Every idea they have equals money out, not money in. So if that's your way of thinking, then probably you won't, the things discussed in this video would have never crossed your mind, right? But if you have an investment mindset, and that means you're also looking ahead into the future, then these topics can become interesting. And then I would highly suggest you seek the advice from the professionals, specifically a tax professional and a law firm, a lawyer. If you want to, you can just brainstorm with us. You can always book your Rent My Legal Brain session, and we can assist you. You can choose your own package, your own plan, and we can assist you the way you want to. But or maybe you have your own attorney, then you can go talk to that attorney as well. But the point I want to make is, you need to think about first what you want to achieve, and then afterwards go and seek the advice before you make a decision. Don't say, you know what, I'm gonna keep it in my name because that's a lazy thing to do. This is my advice. Even if that's you're planning on doing that, just figure out just for yourself, what legal implications does it have? What risks am I running, if any? Right? It's been a pleasure to serve you once more. Once again, thank you for the positive feedbacks that we are receiving. The contents discussed in this video are purely for information purposes. If you need tailored advice, go speak to your lawyer. If you're watching this on LinkedIn, follow us and connect with us. And if you're watching this on any other platform, subscribe and or share and or I mean, there are a lot of things, right? But you can do any either one of those things. So you can keep in touch and stay up to date when we drop a new episode. If you have any questions, feel free to put them down in the comments as well. So we will discuss them in next time. It's been a pleasure. And until next time, take care.